the infamous Catwoman, who is known to use a cat o' nine tails as her signature weapon. When she whips it, she commands your attention. Now tell me, who would not want such power? But remember, absolute power corrupts absolutely, as Lord Acton stated. Honorable Mr. Justice Ivor Archie, Chief Justice of Trinidad and Tobago, distinguished judges, lecturers, fellow participants, and guests, good morning. Today I present on the topic, should the sentence of beating by the birch or cat o' nine be enforced? The instance I have previously highlighted is a glamorized use of the cat o' nine, but there is more to it than what meets the eyes. A cat o' nine tail, also known as a cat, is a whip with 9 knotted lashes, or a rod made from the branches of the tamarind tree. It was used during the slave trade to punish African captives. It is a callous, inhumane form of corporal punishment, and as such, I strongly affirm it should not be enforced. This slavery era law was moved from the statute book in Great Britain and has been abolished or declared unconstitutional in Barbados, Jamaica, and St. Vincent and the Grenadines, for example. However, Trinidad and Tobago has never banned the cat. Under the Corporal Punishment Offenders Over 16 Act, 1953, the use of the cat was limited to male offenders over the age of 16. The age limit was raised in 2000 to 18. Do you remember when your parents would send you for the belt to punish you? You would choose the thinnest one. However, in this situation, there is no choice. The prisoner is stripped completely, placed lying on his stomach on a bench, handcuffed and flogged repeatedly akin to slave conditions. Is it that we miss slavery so much that we want a daily reminder? Contrary to the law, Myra Backbonsey, a 45-year-old mother, was sentenced to 10 strokes with a cat in 1996. This violated the law which stated any male offender over 16 years could be flogged. One would think that laws imposing such severe, savage punishment and the violations to one's human rights would be adhered to in its strictest sense. In 1998, Edward Boucher received 15 strokes with the cat. He was originally sentenced in 1992 and was awaiting his appeal, but he was still purged. The appeal court judge described this as monstrous, and I wholeheartedly agree with him. In 2005, the case of Caesar and Trinidad and Tobago, the Inter-American Court of Human Rights ordered Trinidad and Tobago to pay US $50,000 to Mr. Caesar for an anachronism and a violation of a plethora of international human rights standards. For example, Article 5 of the Universal Declaration of Human Rights. Some may argue that authorities should not drop the old methods, but instead enforce them to teach a lesson. Others say criminals who commit such brutal crime, murder, treason, or rape, they need strong punishment or else they will offend. Others say getting locked up is not good enough. But I ask these questions. What happens when an innocent person who was wrongfully convicted is subjected to this treatment? What purpose then does it really serve? And we turning these administrators of this punishment into sadistic potential criminals? Think about this for a minute. I am convinced that these offenders, when released from prison, they will not be adequately prepared to be reintegrated into society. They will be void of all emotions. They will be worse than when they went in. Although it is not enforced generally, I do believe that countries that have this still in their laws should get rid of it once and for all. Flogging is a barbaric throwback in our faces, as our nations are populated mostly by the descendants of slaves. Flogging, it has no place in a modern society dealing with crime. Flogging is a blatant breach of one's human rights. How can we, with one hand, fight for reparation against the past wrongs inflicted on our ancestors, yet we use the other hand to implement the same nefarious treatment on our people? It then becomes a situation of same script, different cast. I thank you.